Welcome everybody. Good morning and thank you for joining our webinar today. So our panelists today are Caitlin Anderson, Peter Wiltenberg, Stephanie Fedorka, and Teresa Resnick, who will all be contributing to our Business in 2021 webinar series. Before we begin, just a little bit of housekeeping. Please use the Q&A button at the bottom of the screen to submit any questions to our panelists. Time allowing, questions will be answered at the end of the presentation. So without further ado, I would like to introduce Erin Torcello, who will help us kick things off today. Erin, take it away.
Thank you, Matt. Good afternoon, everyone. Thank you for having me as the fill-in moderator this afternoon for Adam and Andy. Welcome back from your July 4th holiday weekend. Hopefully everyone was able to celebrate having a healthy and happy 4th of July, and hopefully everyone's pets have recovered from the nonstop fireworks over the weekend. I know my dog was very excited that last night was pretty quiet. As Matt mentioned, today we are going to start off with Katie Anderson to tell us a little bit about what's happening in Albany the past week. It's been relatively slow, but she has a few things for us. And then we will turn it over to Peter Wiltenberg to talk about some updates with regard to the court challenges to the mandatory vaccine policies that we've talked about on a number of occasions throughout this series. And then we'll have Stephanie Fedorka talk about the HERO Act and where we stand with that, and whether or not the state has come out with the template policies yet. I won't spoil or, take away Stephanie's thunder on that. So I'll let you talk about that, Stephanie. Although I think we can all guess what the answer is going to be. And then lastly, we will turn it over to Teresa to talk to us a bit about COVID-related leaves, what the status of those leaves are, and especially in light of the fact that we are no longer in a state of emergency, and how to handle some of the practical impacts and implications of the COVID-related leaves. With that, Katie.
All right. Yes. Thank you, everyone, for joining us again. I know that it was a restful weekend for me. I hope you had either rest or, something else that was good for that time period. But what else was resting during the 4th of July weekend? And that was a lot of news out of Albany. Most of the news was just about the plight of fireworks that were occurring everywhere in the state. But, good news for all of us. It's less that we need to digest. But don't worry, I've always got stuff to talk about. First thing, cases in New York State, COVID cases remain low. We've seen a slight uptick in cases that represents the Delta variant. But by slight uptick, I mean we went from 0.3% of positive test results to 0.76. So not a huge increase. This is again primarily driven by the Delta variant in unvaccinated individuals. And so we will continue to watch what's happening there. In terms of vaccinations in New York State, the numbers really didn't change a lot from last week. They all remained pretty much the same, except that 66% of New Yorkers 18 and older are now fully vaccinated. Hopefully we'll be seeing that number go up soon to 70%. And one shot is not going to do the trick. So turning then to last week, we got a lot of questions about what are the emergency regulations from the Department of Health that are still in place. So I figured worthwhile to go into the one that's going to matter the most to all of you. It's the regulation about enforcement of social distancing measures. This regulation requires unvaccinated individuals who are over 2 years old, who can medically tolerate the face covering, to wear one in public or when social distancing cannot be maintained. So if you have an employee in your office who's unvaccinated, if they're seated, they're 6 feet away, at least 6 feet away from another person, they don't have to wear their mask then. But if somebody comes into contact with them, if they get up and move around, they should put a mask on because of your concerns with vaccinations and masks, and because this is a requirement under these regulations. Businesses still have to provide face coverings to employees. That hasn't changed. That rule has been around for a long time. And finally, looking at what indoor venues have to do. They have their own specific set of rules. If you're having more than 5,000 people at an indoor venue, if you are, I strongly encourage that you give us a call, because there's a lot of complexity there about what you have to do. One question we get a lot What about somebody who has recovered from COVID-19, but it's not vaccinated? Do they still have to wear the mask? Yes, there's no exception for them under this rule. And remember, this is a regulation, it's law, and they need to wear a mask. It doesn't matter if they have if they've recovered from it in the past 90 days. That doesn't matter for this rule. They have to continue to wear a mask if they're unvaccinated. And importantly, these regulations are enforceable with penalties. So you can have a penalty that goes to an individual. It's $1,000 to an individual if you're not wearing a face covering and you need to be wearing one, aka you're unvaccinated. And it can be a penalty of up to $1,000 for any entity that fails to comply with these regulations. So failing to comply would be anything from failing to give out the face coverings to employees to potentially failing to enforce the mandate that unvaccinated individuals wear face coverings. Remember, New York State has said that a proper way to check to see that if people are unvaccinated is to use the honor system. If you're using the honor system, if you're clearly saying, look, if you're unvaccinated, continue to wear a mask, you're likely going to be just fine under this. We really haven't seen a lot of enforcement measures brought under this penalty regime, but worth knowing that they're out there, worth knowing that there are penalties that exist, and what implications that it could have on your business. In the past week, the governor has signed about 45 bills into law. Remember, at the end of session, the legislature passed 600 bills. And so that's a lot of bills to work through. So the next few weeks, I'll be kind of in this segment, I'll be highlighting either bills that the governor has signed or bills that are still waiting to be signed by the governor that are of interest. There's a ton of bills out there that are of interest to all of you, including one that would allow for electronic notarization. That one, we're still waiting for the governor to sign that as well. When that went away suddenly because of the end of the state of emergency, that bill became really important. Same thing with expanding liquor license premises. That is also a bill we're waiting to see what the governor's going to do with it. But what bills did the governor sign this week? Here's two that may matter to you. Public employers. Public employers cannot take a retaliatory adverse personnel action against an employee who used their sick leave or other compensatory time to quarantine or seek medical treatment, or had other absences related to COVID-19. This has a retroactive effective date to January 1st, 2020. The reason for this bill becoming law is the New York City Department of Corrections was issuing a lot of adverse actions against employees who were quarantining because it was required under the law. But then we're issuing adverse actions against those employees. So this law is to protect those employees. Also of interest is the Gender Recognition Act. This bill, this law now will allow people who are transgender, who are non-binary, or whatever the case may be, to have a new driver's license where your sex designation is either male, female, or X. Also, a big thing that I learned too was I didn't realize that when you had to have a name change on your birth certificate, it had to be published in the newspaper along with your old name. And so obviously that creates a lot of safety concerns for especially for transgender folks who often face a high number of hate crimes. So that has changed as well. Finally, today we are hoping to get results for the New York City mayoral election. It's the first time ranked choice voting has been used. It's taken a long time to count the votes because one, ranked choice voting, two, the Board of Elections in New York City is a mess. And then three, they waited for now 3 weeks almost to count the absentee ballots because they wanted to make sure that they received all of the absentee ballots that were sent on election day. Very close race right now in New York City. It will be decided by these 125,000 absentee votes. So with that, Erin, so much for saying that there wasn't a lot of news in Albany. There's always news.
Thank you, Katie. Going back to the regulations that you were talking about, those were issued through the Department of Health, correct?
That is correct. And they don't depend on any emergency executive order. to be around. They are based on the public health law, which is a statute. So the Department of Health is able to then issue these emergency regulations because of that statute, not because of the executive orders.
Thank you very much. All right, and now we are going to turn to Peter Wiltenberg, who is an associate in our Buffalo office. And today he's going to update us on the court challenges to vaccine mandates. As we've reported on a few times throughout the course of these webinars, there have been a series of court challenges to employer policies requiring mandatory vaccination for their employees or certain portions of their employees. So with that, Peter, take it away.
Thanks, Erin, and good afternoon, everyone. Employers are considering a lot of issues around vaccination, including whether to mandate vaccination for their workforce. Both anecdotally from our clients and from published reports, we've seen that the vast majority of employers have not been mandating vaccination for their employees. But that could be starting to change now. I just saw some news reports this morning that, first of all, cases are rising in about half of the states, mostly due to the Delta variant, and that a few more prominent companies in the tech industry and some other places have come out and announced that they will require their workforce to be vaccinated. So as the rate of vaccination of people who are getting it voluntarily really levels off, and as a significant portion of Americans are deciding not to get the vaccine, if that's their choice, more employers may be considering mandating the vaccine. And so there are a number of reasons why, we think and we've heard that employers have been choosing so far not to mandate the vaccine. One of those is definitely that in this environment, employers have had a hard time either hiring or retaining workers and don't want to impose any policies that might shrink their potential pool of workers. Some employers might feel that it's safe enough for their employees if most of them are vaccinated voluntarily and the others who aren't vaccinated have to wear masks when they can't maintain social distance. There's definitely the potential for bad PR or employee morale problems by mandating vaccines. But as Erin alluded to, and I'll talk about today, another significant consideration for employers is that they're afraid of getting sued if they mandate that their employees get vaccinated. So I'll give a brief overview of some of the lawsuits that have been filed so far challenging employer vaccine mandates. Before I do, though, I think two pieces of background info are just relevant to discussing the cases that have been filed. So the first, as everybody probably knows, is that the FDA has only authorized the use of these vaccines for emergency use. The vaccines are still going through the process of obtaining full FDA approval. So what does that mean? In simplest terms, it means basically that in issuing the emergency use authorization, the FDA essentially determined that certain emergency conditions are present and that the known and potential benefits outweigh the known and potential risks. The vaccines were still required to go through the full 3-phase clinical trial, the same as they would for the normal approval process. And we don't know exactly how long it's going to take for full FDA approval of any of the vaccines that are currently in use, but the earliest estimates I've seen are sometime around the fall. And the other piece of background info that's relevant to all of these cases, which has, I think, been discussed at length on some of these webinars before and in articles on our website, is that the EEOC has issued some guidance about vaccine mandates. And while it's much more nuanced than this, it's generally said that in most circumstances, employers are not barred by federal anti-discrimination laws from mandating vaccines, so long as they make reasonable accommodations for disabilities and sincerely held religious beliefs. So with all that background, the cases, there's basically been there was what I would call a first wave of cases that were filed in the spring when the vaccines were still really new. And they were brought in federal courts around the country, first in New Mexico, then California, North Carolina, and then Texas, by employees challenging a vaccination mandate. And these were kind of general challenges to just the vaccine mandate in and of itself. And while the theories in each case differed slightly, and they each involved state law claims that were particular to those jurisdictions, All of the cases are basically based on the fact that the vaccines are only right now approved for emergency use. The common thread throughout all these cases was essentially that the employees are being coerced or forced into taking an experimental vaccine, and that this violates a number of provisions of federal law that the plaintiffs have alleged, and some of them have even gone so far as to say that these mandates violate the Nuremberg Code's prohibitions against medical experimentation without consent. So the employers have filed motions to dismiss in those cases. And a couple of weeks ago, on June 12th, we got a decision in one of those from a judge in Texas. So that judge dismissed the lawsuit that was brought there. It was brought by employees of a private employer hospital. And so that decision thereby upheld that employer's vaccine mandate. In doing so, the court held a number of things. First of all, that the federal law that was cited by the plaintiffs, which is the same law that the plaintiffs in all four of these federal cases have cited, does not create an individual right or a private right of action for an employee to start a lawsuit. And it also said that that law, which is the same one that authorized the emergency use authorization process in the first place, does not create any additional obligations for employers. The court also dismissed the argument that employees who are subject to a vaccine mandate are essentially being treated as human subjects or as part of a human trial. The court dismissed that argument and said that this is not the same as a clinical trial. On the state law claim that was brought under Texas law, the court essentially said that the vaccine mandate doesn't fall within Texas's narrow exception to its at-will employment doctrine. And so that was basically the balance of the plaintiff's claims. It's worth noting that this was pretty much a scathing decision, and the judge made it entirely clear that he didn't like the plaintiff's arguments in this case at all. The plaintiffs argued basically that the emergency vaccine is experimental and dangerous. The judge called that argument false. The judge called reprehensible some of the plaintiffs' claims that likened the vaccine mandate to medical experimentation that gave rise to the Nuremberg Code after the Second World War, and concluded the decision by saying that the plaintiffs will take nothing from the hospital. And that might be common phrasing in Texas, but in my world, I've never seen a judge use that phrase when concluding a decision on a motion to dismiss. But the kind of the gist of the decision, which the court also articulated at the end, is that the employees were not being coerced or forced to take the vaccine. They're in a voluntary employment relationship, and voluntary employment is subject to all sorts of conditions that an employer can rightfully impose, and that these conditions, the vaccine now being one of them, is just simply part of the bargain. So there are a couple of takeaways from this Texas decision. While it's obviously a very good decision for employers, there are a number of reasons why we can't take too much really from it as it might apply in other circumstances. First of all, it's going to be appealed. So the appeals court there in the Fifth Circuit could decide that even if the case ultimately doesn't have that much merit, at this stage, it did allege enough to move past the motion to dismiss stage. Right now, it's limited to that jurisdiction, which is the Southern District of Texas. And even if it's upheld on appeal, that's still just going to be the Fifth Circuit. The state laws, this case only pertained to Texas law, and other state laws could be far more permissible in some of the ways that they allow wrongful termination claims. This case finally was brought against a private employer, and the three remaining federal cases were all brought against public employers. And the plaintiffs in those cases raised some different arguments that weren't raised in the Texas case, essentially because the mandate coming from those public sector employers was, in their view, basically an act of the state government, which gives rise to some other issues. So since that Texas case came down, another very interesting case was filed, and this is much closer to home and much more immediate relevance to all of us. So a couple of weeks ago in Queens, there was filed a lawsuit challenging a vaccine mandate under a disability theory. So this is one of the first cases that I'm aware of that goes kind of beyond these general challenges to the vaccine mandates that we saw in those federal cases, that's and based solely on the fact that the vaccines are only authorized under the emergency use authorization. And now this case kind of ties the plaintiff's objections to the vaccine to her membership in a protected class. So in this case, the plaintiffs are women who are trying to get pregnant via an intrauterine procedure, and they objected to taking the vaccine on the grounds that they feared for the safety of themselves and the potential fetus due to the unknown health effects of the vaccine. When they refused to get vaccinated, they were furloughed by their employers. They cited fear of adverse health effects, their right to bodily autonomy, dignity, privacy. They had a doctor's note that basically said that it's not safe or at least unknown for pregnant women and was likely to cause injury and harm. They also relied on the fact that the vaccine is also approved for emergency use only, and they called it experimental throughout the complaint. Their claims were brought under New York State and New York City human rights laws, alleging employment discrimination based on disability, failure to accommodate, and retaliation under the labor law's whistleblower provision. So I think this is going to be an early kind of test case for the boundaries of how far reasonable accommodation needs to go for certain health conditions, especially pregnancy, and the vaccine. So that case is still really early. The defendants haven't answered or filed a motion to dismiss yet, but we're definitely going to keep an eye on that and any other similar cases. So basically from all this, I think there are a few takeaways from employers, even though this is still really early on these cases and there's not really very much hard kind of data that we can glean from them. The early indications, nevertheless, are that these lawsuits challenging the mandates, especially the ones that are only based on the theory that the emergency use authorization is experimental, we think that those probably have a low chance of succeeding on the merits. But there's still a lot of considerations for employers. The first is that the law around the emergency use authorization and especially this COVID vaccine is basically non-existent. There's not really any precedent for judges to follow. And that means that it's going to be somewhat unpredictable when these cases are filed, even after results like the one in Texas. Employers also know, quite well that it's very costly and burdensome to have to defend lawsuits. Even ones that they ultimately prevail on. And it's certainly the case that there's going to be at least some additional risk of having to defend against a lawsuit if you decide to mandate vaccination for your workforce. These cases pretty much always generate a lot of publicity, even in the mainstream press. And so that's certainly something that employers are going to want to avoid. And then finally, the cases, at least to the extent that they're still based on the theory that these vaccines are only approved for emergency use, they have a limited window because there's probably only a couple more months before at least one of the vaccines is fully approved by the FDA. But a lot can change in the next couple of months. There's still that several month window for these lawsuits to probably be filed on that same theory if a mandate is imposed during that time. And it's going to be especially relevant consideration to higher education employers because that is one of the industries where vaccine mandates for students and employees has been far more common. And as students start to return, and faculty and employees start to return to campus in the next couple of weeks, there may be an opportunity there for some lawsuits challenging some of those mandates. So we'll keep an eye on all that. If you're considering any questions around vaccine, definitely give us a call.
Thank you, Peter, very much. There's a lot of information there. We really appreciate your insights in terms of next steps and the considerations that employers should think about if this is a policy or a path that they're thinking about taking. So now we're going to turn to Stephanie Fedorka. She has become our resident go-to for all things HERO Act related. Stephanie presented for us at least last week, and I know she's done a number of other presentations on the HERO Act. I'm sure many of you are perhaps not so patiently waiting for the state to finally issue the template guidance and model policy concerning the HERO Act. And Stephanie, I will let you take it from there to let us know where we stand.
Thanks, Erin, and thank you all for joining us this afternoon. It's a pleasure to be back and give you a little update on the HERO Act. I thought it was timely given the effective date that we'll talk about in a couple slides. Matt, could you advance the slide, please? Thank you. So the New York HERO Act, if you recall, I've spoken previously about it, but just in case you don't or are not aware of it, the New York HERO Act essentially adds 2 new sections to the New York labor law. New York labor law section 218B, which pertains to airborne infectious disease exposure prevention plans, and New York labor law 27D, which pertains to joint labor management workplace safety committees. Note that this applies to private employers only. And today we are just going to be focusing on New York labor law 218B because of the effective date. So New York labor law 27D that has to do with the workplace safety committees does not go into effect until November 1st. So we're going to tuck that aside just for today's purposes. Next slide, please. Thank you. So just a quick recap of the main provisions of New York labor law 218B. The new effective date, the original effective date was June 4th. As you probably know, there were amendments that were passed which pushed the new effective date to July 4th. But since that was a holiday, you can read it as July 5th. I'll even give it to the 6th, honestly, because of Monday being a recognized holiday. So it only applies to covered employers or private employers, I apologize. There's no size threshold. So all private employers in New York State have to adhere and abide by this new section 218B. Essentially what this provision does is it requires the New York State Department of Labor to publish model prevention plans or standards. And then employers will have 30 days from that date to publish, to either adopt one of the appropriate models for their industry. There will be some industry specific prevention plans and standards, and there will be one general kind of miscellaneous, if you will, general prevention plan standard model policy as well. Or an employer can develop and adopt an alternative plan that meets or exceeds the minimum standards. Next slide, please. It also provides that employers must provide written notice of the plan to employees on certain specific occasions. So if the business is open on the effective date, so if you're currently operational and open, then employers will have 60 days from the date that the New York State Department of Labor publishes the model standard relevant to that industry to provide your employees with a written copy or written notice of the plan. You'll also have to provide it within 30 days after adoption of a plan. So in my mind, that means, and this can be confusing how it's written, but if an employer or an organization that would be covered under this law is not in existence and you're a new business that comes out in December and you have to adopt or develop one of these airborne infectious disease prevention plans, then you'll have 30 days after adoption of the plan to provide notice. Or if you were to change your prevention plan for whatever reason, then I think you would have 30 days again to provide written notice of the plan to your employees. You also have to provide your employees with a written notice of the plan within 15 days after reopening, after a period of closure due to airborne infectious disease, and upon hired to newly hired employees. Note that there is a posting requirement. These will need to be posted at each work site, excluding vehicles. And if an employer has an employee handbook, a copy of this plan must be included in there as well. That's pretty clear from the language in the statute. Next slide, please. So this brings us to, okay, it's officially effective. What do we do now, right? Since July 5th has come and gone, we're sitting here on July 6th. Anxiously awaiting for the New York State Department of Labor. We thought maybe they would be pushing or publishing the model prevention plans out by now, but next slide, please. Don't panic. The New York State Department of Labor has not published those model plans. I have been anxiously refreshing my browser. As you can see, the New York State Department of Labor has a website set up already reserved for New York HERO Act information. Right now, it's a very, very brief. It just has a couple of bullet points on what the HERO Act is, and it says check back later for updates. So I have been refreshing. We don't have the model prevention plans yet, but again, don't panic. Employers have 30 days from when the Department of Labor publishes those model standards in order to adopt a model prevention plan or an alternative plan. Next slide, please. So what can we do? Should we be doing right now? I know it's hard, but being patient and waiting for the New York State Department of Labor to issue those model standards, because you can't even really begin to develop your own or start working from anything if you don't have the model standards and the minimum standards to work from, since that is going to be the threshold for compliance. So again, you have to be prepared for when they are published, because you do have to act relatively quickly. You'll only have 30 days to either adopt a model plan or develop your own. And recall that developing your own is going to require adhering to collective bargaining agreement provisions and negotiating those plans perhaps. Or if there's no bargaining representative, it still requires quote unquote meaningful participation of employees. So even if you're not in a unionized workplace setting, you still have to engage your employees to develop these model or these prevention plans. So develop a plan for how your organization is going to evaluate the model plans. As soon as they come out, you should be prepared to evaluate it. Who's going to evaluate it? How are you going to evaluate it? And how you'll determine and decide whether or not adoption of one of the model plans or standards is best for your workplace, or whether developing an alternative plan is better for your workplace. So you should have a plan at least ready to go. So as soon as the New York State Department of Labor issues those model prevention plans, you can hit the ground running and be within that 30-day deadline. Next slide, please. You should also be determining who the supervisory employee in charge is going to be in charge of compliance with the plan and guidance. There is a requirement in the plan, and those will be, it's one of the bulleted or enumerated items in the statute of what needs to be covered and included in the prevention plans. A supervisory employee will need to be designated to be in charge of compliance with the plan and any guidance that comes with that. So determine who that person might be, or at least think about who that person is going to be. And then budgeting for cost of compliance, right? Consider the additional cost of PPE, cleaning, training, or any other budgetary items that we've learned in the past 16 months or so from being in this, of what have some budgetary line items to adjust and account for, since this will be with us indefinitely into the future. So those are, that's the update. We will be awaiting the published model prevention plans, and we will be checking on those, so you can rest assured that we will publish either an info memo, blog post, and let you all know when those come out.
Thank you, Stephanie, very much for keeping on top of this. We appreciate your efforts. Hopefully you don't have to spend too much more time today continuing to refresh your screen, but I know better.
Fingers crossed. Not holding my breath.
All right, thanks, Stephanie. And now, last but certainly not least, we are going to turn it over to Teresa to talk briefly about where we stand with the COVID-specific leaves that we've seen over the past 18 months or so. Now that the numbers are dwindling, vaccine rates are rising, and we, at least in the state of New York, are no longer under a state of emergency, this has raised a number of questions concerning what are the status of the COVID-related leaves? Do we still need to provide paid leave where somebody has a mandatory order of quarantine or is exhibiting symptoms of COVID or has tested positive for COVID? And Teresa's here to tell us the status and what we as employers have to do, what our obligations are with regard to those leaves. Thank you, Teresa.
Thanks, Erin, and hi, everyone. I don't think it's giving anything away to say that the leave laws are still with us. The state of emergency may have gone away and vaccination rates may be up, and those are all very positive signs. But to the extent people are still subject to orders of quarantine, the leave laws are with us. And of course, we still have some federal provisions with us as well. So if I could have the next slide, we can get started. So starting off with federal, the American Rescue Plan Act is still in effect. If you recall, that was the one that extended and expanded the Families First Coronavirus Response Act. President Biden signed that late March of 2021. It became effective in early April of 2021. Basically, it extends the EFMLA and EPSL through September 30th of 2021. As you remember, that is a voluntary extension. Employers do not have to extend EFMLA or EPSL. In fact, it's rather likely that they don't have to extend both. They can choose to extend one or the other. Although keep in mind that if you are going to extend one or the other within the different categories of reasons that you have to allow someone to take EFMLA or EPSL, you have to allow them to take all categories. And you can't discriminate, only give EPSL to your employees who are over 50 or under 50, or, discriminate based on age or race or any of our other protected categories. But barring not doing any of those things, the EFMLA and EPSL is still eligible for voluntary expansion through September 30th. As you may remember, there's an expanded list of reasons for taking the leave. As an initial note, EFMLA, which remember provides for 2/3 of pay for up to 12 weeks, subject to a cap, can be taken for all of the EPSL reasons. It's no longer restricted to childcare the way it was before we had the ARPA. Also, you can now take the EPSL and EFMLA to get the vaccine for vaccination side effects, as well as for awaiting the test results or medical diagnosis of COVID-19. The tax credits do apply for the ARPA at least through September 30th. Will that be extended again through the end of 2021? I'm not sure. It may very well be, given what Peter said about cases rising in other states. Remember, this is a federal mandate or a federal benefit, and obviously it affects more than just New York. So it may continue to get extended. I'm sure that will still be voluntary for employers. Next slide. Turning now to New York. New York has a number of paid leave laws that we saw for COVID-19. I'm going to start with the first one that we saw, and I'm going to tell you that it's still around. The New York COVID-19 leave law. This is the one that we saw at the very beginning of the pandemic. This was before the FFCRA. This was before the federal government did anything. This is the leave law that provides for 5 or 14 days of leave when an employee is subject to a mandatory order of quarantine. Couple of things. The amount of leave is based on the size of the employer. If you have over 100 employees, you have to, sorry, I just for a minute, I had to remember that. If you have over 100 employees, you have to give them 14 days of leave. You also have to give 14 days of leave for public employers. If you're under that amount, it's 5 days of leave. And then if you're a super small employer, you have to give the 5 days, but they can be unpaid. There is no tax credit for this. Unfortunately, New York was not as generous as the federal government. There is a requirement that this leave be given when there is an order of quarantine from a state or local health department or a government agency. This is different than the federal laws, which said you could get the leave under a wide variety of conditions, including seeking diagnosis or for a child's quarantine or something like that. This is more narrow. This is only if the employee is subject to a mandatory order of quarantine, and that can't be from a doctor's office or, just based on the employee's own initiative. That has to be from a state or local health department or a government agency. This is offered in addition to New York State paid sick leave, which we'll talk about in a minute, and any PTO or other sick leave offered by the employer. So even if you give your employees 100 days of sick leave to use every year and 3 weeks of vacation and unlimited PTO or whatever it might be, you still have to give them this time, should they be subject to that order of quarantine. I have a little reminder with an asterisk here. I think this is a good reminder for everyone. We're starting to see some DOL enforcement action on this guidance. If you recall, back in January, when we were just starting to emerge from the pandemic, New York State issued this guidance document, or rather the New York Department of Labor did, which really expanded the New York COVID-19 leave law in a variety of circumstances. There's been a lot of debate over how effective that guidance can be, how legally binding it can be, given that it seems to exceed the statutory mandate by quite a bit. Given that it's just a guidance document, it's not a regulation, it wasn't published pursuant to a rulemaking or anything that we would normally see for a binding effect from the Department of Labor, but there it is. And we have received anecdotal information that DOL is interpreting that guidance pretty stringently and is moving to enforce actions against employers who do not follow it. So if you do end up in one of the situations where the New York DOL guidance might apply, feel free to reach out to your attorney and we can walk you through the nuances of that. Next slide, please. New York leave law for vaccinations. So we also saw a separate leave mandate for vaccines. Employers must permit employees up to 4 hours off per vaccination. This leave, again, is separate from New York PSL. It's separate from the New York COVID-19 leave, and it's separate from any other sick or paid time off that an employer might offer. You could likely, if you extend the ARPA, receive the ARPA tax credit for giving this leave, even though you're required to give it under New York law. I don't see any conflict with that, but of course you would have had to extend ARPA to do that, and not all employers have. And then finally, with New York State paid sick leave, as you remember, this is our broad paid sick leave mandate that started on the first of the year. The governor recently released information, and the State Department of Labor confirmed it, that employers must allow employees to take New York State paid sick leave to recover from vaccination side effects. However, that is not, unlike everything else we've just talked about, adding a new category of leave. That's just simply clarifying that employees have to be able to take New York State paid sick leave to recover from the vaccine. Remember, that's different than actually getting the vaccine, which is a separate 4-hour leave mandate. All right, and next slide. Yep, all right, I thought that was my last one. Thank you, everyone. And Erin, I'll send it back to you.
All right, thank you, Teresa. Thank you to all who have joined us this afternoon for this post 4th of July webinar. Thank you to all of our presenters for agreeing to do a post 4th of July seminar. I really appreciate your willingness to jump in today to provide this information to those who have joined us today. If you have any additional questions, our presenters' contact information is on the presentation. Please feel free to direct any additional questions you have to them, and we look forward to seeing you next week.